If this is your first time here, I'm glad you found this series. We explore the right of disposition, the legal right to control what happens to your body after death, and how to make sure your wishes are honored exactly the way you intend. This episode focuses on Kentucky, where state law gives you clear authority to decide who handles your final arrangements, but only if you put it in writing. In Kentucky, you can choose who will be in charge of your funeral, burial, or cremation by completing a funeral planning declaration. Under Kentucky Revised Statute 367.93117, you can name an individual called a designee who has the legal right to make decisions about your final disposition. Once the declaration is properly signed, dated, and witnessed, that person's authority overrides everyone else's, even your family. Your chosen designee becomes the sole decision maker for your arrangements. If you do not complete a declaration, Kentucky law decides who has that authority. First, the person appointed in your written declaration. Next, your surviving spouse. Then, your adult children. A majority if there's more than one. After that, your surviving parents. Then, your adult siblings, followed by your surviving grandparents, adult grandchildren, or next of kin under Kentucky's succession laws. If no one is available or willing, a court or local official may make the final decision. This order is clearly defined in Kentucky Revised Statute 367.93117 and is what funeral homes must follow if no written plan exists. Timing also matters in Kentucky. If no one claims a body within 30 days, it can be declared unclaimed, and the county or coroner may authorize cremation or burial. That 30-day window can close quickly if there's disagreement, distance, or no clear direction. By completing a funeral planning declaration, you ensure your wishes are followed immediately without delay or confusion. If you're estranged or no contact with your family, the law still defaults to the family hierarchy unless you've completed a declaration. That means a relative you haven't spoken to in years could legally take control of your arrangements. Signing a declaration gives that control to someone who actually understands and respects your wishes. Kentucky law doesn't specifically mention chosen names or gender identity in its funeral planning statutes. If you go by a chosen name or live under an identity different from your legal records, include those details clearly in your declaration. Note your preferred name, pronouns, and how you want to be represented. Give copies to your designee and funeral home to ensure your identity and legacy are honored the way you intend. Before we close, let's talk about a few common mistakes people make when it comes to final arrangements in Kentucky. First, assuming a will controls funeral decisions. It doesn't. A will is often read after your services, so it's too late to help. Second, not having witnesses. Kentucky law requires your declaration to be signed in the presence of 2 adult witnesses or notarized. Without that, it's not valid. Third, failing to update your declaration. If your relationship or wishes change, update the document and give new copies to your designee and your funeral provider. Avoiding these mistakes ensures your arrangements go exactly as planned. No confusion, no delays, and no disputes. Thank you for watching. I hope this helped you understand how Kentucky handles the right of disposition and why documentation is such an important form of self-protection and peace of mind. If this information helped you, share it with your family, friends, or anyone living in Kentucky who may not know these laws. Conversations like this make it easier for loved ones to honor you exactly as you wish. Be sure to like, comment, and subscribe for more state-by-state episodes in this series. And check out the rest of my Right of Disposition playlist to see how laws differ across the country. I'm Bella, but this is your life, your legacy, and your choice, even after you're gone.